Mr. Lawson.
Good morning, may it please the court. Nick Lawson on behalf of the appellant, Brad Miller. This, Your Honors, is an ERISA benefits case. The plan administrator denied the appellant's request for separation benefits following Anadarko Petroleum's acquisition of Anadarko in 2019. In the district court, Judge Rosenthal in the trial court affirmed that decision, and when she did, she erred for two reasons. The first reason is she applied an abuse of discretion standard when the plan didn't allow for it. And the second reason is that the plan administrator's determinations were not supported by substantial evidence. So on the abuse of discretion standard, Judge Rosenthal framed up at the beginning of her opinion that she was stuck between this court's decision in Gift and her own decision in Lieu versus the 10th Circuit's decision in Hall. And the Gift and Lieu decisions control her. But I think this court should take the opportunity to follow Hall. And the reason is Hall was based on a more full record. In other words, this issue was fully argued in that case, whereas in both Gift and Lieu it was not. In both Gift and Lieu, the employees seeking benefits did not dispute that there was discretion in the plan. Whereas in Hall, it was disputed. In the court in Hall, including the 10th Circuit, was able to fully analyze that issue and come to a determination.
Well, I'm having to dredge up in my memory many ERISA cases because I haven't had one for a while. But I do not recall splicing and dicing the question of a committee's discretion among various provisions of a plan, which is what I apprehend you're trying to do, because you're trying to say the term material alteration, good reason, is clearly ambiguous. But when you get down to the more precise things about material changes in salary and so on, you're saying those are sufficiently unambiguous that the committee had no discretion? Is that what you're saying?
Well, in some ways, yes, Your Honor. What I'm saying is, when we're slicing and dicing the discretion, all we're actually doing is just following the terms of the plan. The plan, as this court understands, the general rule is that plan administrators are entitled to no deference. It's de novo.
Right. But if they have discretion, they have discretion.
Correct. But that discretion is limited by what the plan says. Right? And this plan doesn't give discretion for all things. It only gives discretion for certain things. And that's, unclear, ambiguous, implied but omitted terms. And we can, argue about whether or not that exists in this case, but what's important to note is that the plan administrator never thought that there was an ambiguous or unclear term when it made its decision. And because of that, the plan administrator is not entitled to discretion. It's entitled only to de novo review. And that's exactly what the 10th Circuit found.
Where are you importing this idea that they thought there was no ambiguity?
Well, from the record, Your Honor, any time that they made a decision with respect to Mr. Miller's benefits determination, they never said there's an ambiguous term, there's an unclear term.
Well, do they have to say that?
I think they have to.
Okay, what's your best authority for that?
Oh, Your Honor, I don't have a specific case that would
Okay.
I don't have a specific case.
Okay.
But the litigants, how are the litigants to know if there is an ambiguous term unless they tell you that it is? And they never have, including in their briefing to this court. Instead, what they say is the fact that the parties are arguing about it, that shows that it must be unclear. But that's not how the analysis works, right? The court needs to be confronted with one or more reasonable interpretations.
But couldn't it also be that even if the term was ambiguous, that you would not be successful as a matter of fact either way?
No, Your Honor, I disagree with that as well. That's my second argument, which is that the plan decision from the plan administrator was not based on substantial evidence. There are a few, examples that I'll point to in that when this gets to that part of the argument.
I'm not trying to get too far ahead of you. I'm following what you're saying. it occurred to me when you made the argument that could also be a contingency.
Sure, and we are arguing that. And I'll answer your question on that. So the reason why the plan administrator's determination was not based on substantial evidence is really twofold. One, the plan administrator read additional requirements into the plan that don't exist, and that would be an abuse of discretion, arbitrary if it wishes to do so. And two, they made decisions that were not consistent with the actual facts that we see in the record that were presented to the plan administrator. So I'll start with the additional requirements that were read into the plan. The first one is a causation requirement. The plan administrator denied Mr. Miller's benefits in part because they said the reduction in his duties and responsibilities was not caused by the change of control. It was instead caused by COVID-19 or other business disruptions. But that causation is not anywhere at all in the plan. What the plan says is that you look before the COC event and what are your duties and responsibilities, and then for a period of 1 year after COC, we look at what your duties and responsibilities are. It doesn't say, and then we compare them whether or not those changes are because of the COC or for other reasons. It doesn't. And this, I'll remind the court, this is a contract between employees and its employer, right? This is negotiated in advance. And once COC happens, it can't be changed anymore because the event has occurred. So that causation is not a part of the plan. The other requirement that was read into the plan is the concept of permanency. The plan administrator acknowledged that certain of Mr. Miller's duties and responsibilities were, of course, reduced. The biggest ticket item is his expense authority, which was reduced from several $1 million to $12,500, which is a 99% decrease. And what the plan administrator said was, yes, that's true, but it was temporary. Sometime later, which is, according to them, would have happened several months after Miller resigned, sometime later, those benefits were restored. And because they were temporary, they don't count. But the plan also doesn't allow for that. The plan just looks at before and looks at after. And while Mr. Miller was employed after, that responsibility, those duties, were taken away. And that's undisputed. No party disputes that. So I think it's arbitrary and capricious to read in the temporary requirement. Certainly in this case.
Well, but the whole point was to compensate people whose severance was caused by the takeover of the company.
Well, I don't think that's the whole point, Your Honor. I think part of it is to incentivize employees to stick around during a tumultuous time, which is the COC event. You don't want them to leave in the middle of that because if you do, your company is worth less. You don't have to take my word for it, though. That's in the first paragraph of the plan itself. So that is also important. And so that's why the employees will decide, are we going to stick around for this COC event or not? And they have to make that choice based on what they know, which is just the terms of the plan. And the plan doesn't say anything about temporary changes.
Well, let me ask you a question. Since you're relying on Section 9.3G, which has to do with allegedly only ambiguous or unclear terms. But what do you do with the language that says Section 9.3 may not be invoked by any person to require the plan to be interpreted in a manner which is inconsistent with its interpretation by the committee?
Mm-hmm. Well, I think you have to read that in conjunction with the other terms of the plan, which say the committee has discretion in this certain specific context. And I think that just referring back to it.
So you can read sections DNF of 9.3 to decide whether there's discretion conferred. Is that a fair statement?
I think, yes, Your Honor, but it has to be specific to where discretion is referenced. And in this case, discretion is referenced only in that certain contexts, which are ambiguous, unclear, implied but omitted terms. And that's where the plan administrator is allowed discretion. Yeah. In addition to reading additional requirements into the plan, and by the way, even with discretion, the plan administrator is not allowed to read additional requirements into the plan. It can't do that. But aside from reading additional requirements into the plan, there were also decisions that were not based on substantial evidence. And I recognize that bar is not high, is a low bar. But here are some examples. For one, there's after the change of control, let me back up. Immediately preceding the change of control, Miller had a subordinate named Susan Hathcock who worked with him. During the transition, Ms. Hathcock retired, and then Oxy determined that she was important and brought her back. And when that happened, she took about 60% of Miller's regulatory role. If you'll recall, he was Director of Regulatory Affairs and Advocacy. So that's one of his two core functions, was the regulatory affairs. When she came back, she took about 60% of those duties. Okay? And there's no dispute of this, right? Oxy agrees that occurred. What they say, though, the response is that she actually helped Miller. When she came back and took these responsibilities, that was helpful to him. Now, that's not substantial evidence to suggest that that is not a reduction in his duties and responsibilities. It's an agreement that it occurred. And there's more examples as well. For example, Oxy determined that trade organizations, this is the advocacy part. You know, Mr. Miller was Director of Advocacy. And as a part of that role, he went to trade organizations, developed these relationships so that he would have communication with regulators. This is how they did that. That was important to Anadarko. Oxy decided that that wasn't important to Oxy. And so they took it away. And he no longer did that. And they say because it wasn't important to Oxy, it wasn't a big part of his job. But the record shows there's a letter from Alan Sanders, who was Miller's supervisor at Anadarko, where he says it was critical to their function. So it doesn't matter that Oxy didn't think it was important. Anadarko did. And that was one of his duties and responsibilities that was undisputedly taken away. So that decision, not to allow good reason based on his trade organization work alone, based on the record evidence we have, is not supported by substantial evidence.
If that were the only thing that had changed, though, wouldn't you agree that wouldn't be enough to render their decision arbitrary and capricious?
I think it could be, Your Honor, because his role as Director of Regulatory Affairs and Advocacy, those are his two core principles. And if you take one away, that is a reduction in 50% of his responsibility. And I would argue that 50% is substantial. But it is more than that, because he was also reduced in his regulatory role as well. And the third example is prior to COC, Mr. Miller was on a small group, the GOM, Gulf of Mexico Committee. They made decisions for the Gulf of Mexico, reviewed important decisions about Gulf of Mexico operations, and that was headed by Alan Sanders. After the change of control, however, they took that committee away, and they reformed it with a new committee called the Executive Leadership Committee. And that was problematic for two reasons. One, Mr. Miller no longer was a voting member of the committee, whereas before he was. And two, the new ELT committee was much larger, included many more people, so his influence was diminished as well. So not only was he a part of a bigger group, but he also had less influence because he was not allowed to vote. Still, the committee determined that that wasn't a material reduction in his duties and responsibilities because, for them, he had greater exposure to more people. But that is not supported. That's not supported by the evidence nor by the plan. I think we could all agree that a loss of voting power is a loss of duties, and he undisputedly did lose that. I think for these reasons, Your Honor, he's entitled to his plan benefits. And
he is getting retirement benefits, right?
From his 401k, separate and apart from all of this, I understand that is correct, Your Honor.
Okay, just wondering. All right. Thank you. You have your rebuttal.
Thank you.
Ms. Williams.
May it please the Court, Kristina Williams on behalf of the Anadarko Appellees. The District Court correctly affirmed the Plan Administrator's decision, and this Court should affirm the District Court's judgment for two reasons. First, this is a plan interpretation dispute about the meaning of good reason. The District Court correctly applied this Court's standard to the plain language of the plan and reviewed the Administrator's decision for abuse of discretion, and this Court should do the same. Second, under either standard, the committee's decision should be affirmed. Turning to my first point, the district court correctly reviewed the administrator's decision for abuse of discretion. This court has held that plan provisions may be read as a whole, not as Judge Jones mentioned, we don't do splicing and dicing. This court has also commented that most ERISA plans grant deference to the administrator, even when the grant of discretionary authority could have been more clear. No magic language is required, not even the word discretion. Here, the plan provisions grant expansive discretion to the administrator. Section 9.3G has two relevant parts. First, the committee shall have the discretion to make findings of fact, shall have the discretion to interpret or construe ambiguous, unclear, or implied or omitted terms in any fashion in its sole judgment. The validity of any such finding of fact, construction, interpretation, or decision shall not be given de novo review if challenged in court, and shall be upheld unless clearly arbitrary or capricious. Three courts, this court in Gift and the district courts in Liu and Miller, all considered this exact plan language and applied abuse of discretion review. And this court should do the same to maintain consistency. Now, the Gift court held that that was a plan interpretation case, a dispute over the meaning of one similar subsection and a different subsection of good reason event. We have the same type of dispute here. The parties are essentially arguing whether subsections of good reason events apply here. Now, Gibbs and Liu did agree that abuse of discretion review applied. However, Gibbs still challenged the overall review framework. He said that the district court conflated the plan interpretation standards to that for factual determinations. The parties spent 15 pages, roughly, of combined briefing on the standard of review. So I would contend that the standard of review was still very much before this court in Gift. After all, this court has said that it is this court, not the parties, that determine the standard of review. You simply can't consent to a standard of review if it's not the right one. So the court can also look broader than the Gift case. The court can look to the Salomon case, the published decision from the Ninth Circuit, which had extremely similar language to what we have here. The first part of that provision said that the committee could construe and interpret findings of fact and make interpretations. And then it had just about an identical last sentence to the one we have here that said that the administrator's decision should not be given de novo review. There, the Ninth Circuit said that abuse of discretion was the proper standard because that was a clear grant of discretion to the administrator, and more importantly, a very clear statement that de novo judicial review should not apply. Court can also look to the Jimenez case from this court, where there was similar language saying that the plan should not be given de novo review. The court applied abuse of discretion review. My colleague mentioned the Hoff case, and I would urge the court to not follow the Hoff case for a few reasons. First, it's unpublished, it's out of circuit, and respectfully, it was wrongfully decided. So, two main points on Hoff. The 10th Circuit there said that neither party argued that good reason was unambiguous or unclear, so it couldn't reach the question. And we don't have that issue here. Anadarko argued in the district court that if the court found that the decision was not legally correct, that good reason was an ambiguous term, and so abuse of discretion applied. So we don't have that waiver issue, so the court's not bound by that. Second, the 10th Circuit held that the last section of 9.3G was limited to the prior sentence because it included the word such. And respectfully, that disregards the directive in ERISA law, and particularly from this court, that we're to read plan provisions as a whole and give meaning to the word. So the second sentence of 9.3G does state findings of fact, which ties back to the very first sentence. It has interpretations and constructions, which are in the prior sentence, but also adds the word decision. So the court needs to give meaning to that and that clear intent by the administrator, by the plan to give deference to the administrator. So in short, Hoff is the outlier. All other courts that have considered this exact plan and the courts that have considered very similar language have all applied abuse of discretion review, and this court should do the same. Turning to my second point, the committee's decision was supported by substantial evidence. It was not an abuse of discretion. As the court knows under the abuse of discretion standard, a decision is to be affirmed if it is reasonable, even if there is contrary evidence. An abuse of discretion only occurs when it's not based on evidence, it's not rational, and it's not somewhere in the continuum of reasonableness.
Counsel, on what evidence did the committee base its conclusion that the 4.9% reduction in salary was immaterial? Was there some type of evidentiary basis for that, or was that just a judgment call?
So that was, the committee had issued a plan interpretation document prior to Mr. Miller's resignation that said that the 4.9% salary reduction was not material. And the committee did that through its powers to interpret the plan under Section 9.3G, and that's consistent with the definition of material. When we actually look at that salary reduction, it was for a 3-month period, and 4.9% annualized becomes approximately 1%.
Did the committee know that it was a temporary reduction when they issued that interpretation?
Yes, I believe they did, Judge. That was due to the COVID pandemic. But in any event, the committee looked at that. It also, there's no definition of material, so we can use a standard dictionary definition of significant, and there was not any evidence put forth before the committee that 4.9% was material and certainly not annualized. So backtracking a little bit, when we look at Section 2S, a good reason event occurs when duties and responsibilities are materially and adversely diminished or a material reduction of base salary. And we must consider Mr. Miller's job holistically when we look at the first prong. First, because the plan says, quote, duties and responsibilities. That's a plural term. There's S's at the end, and that's an intention for a cumulative look at his entire job. And in fact, the cases that Mr. Miller points to confirm this reading. In all of those cases, the courts look to the entire picture of the employee's job. And in all of the cases where the court found a material diminishment, that's because multiple aspects of the employee's job significantly changed. So looking at that, we have to consider the entire picture for Mr. Miller's job. I would point the court to the DeBurden case from the 7th Circuit as kind of the best example, and we discussed this in our briefing at pages 46 to 49. But there, the employee's duties were reduced from managing 48 to 27 facilities. Not only was his budget cut in half, but he had a loss of management function, hiring and firing authority, lost profit. Essentially, his management job was half of what it used to be. That is a material and adverse diminishment. We don't have that kind of evidence in the record here. And certainly, under the abuse of discretion standard, the committee's decision was supported by substantial evidence. So going kind of through each of those, Mr. Miller contends that his executive-level decision-making was diminished after the change of control. The committee interviewed 4 different people. It took into account the letters and standards, but also interviewed others. And they found that before the change of control, he was a voting member of the GOM committee. After the change of control, that committee did not exist, but it was replaced by a larger committee, the GOM-ELT. And the committee heard from Kershaw that said that Miller's exposure and influence actually broadened after that. And importantly, the committee found that Miller's arguments to the contrary that are in the administrative record were unsubstantiated, and that's at pages 745 and 747 of the record. So the substantial evidence before the committee was actually that he had a greater chance for impact after the change of control. Looking next to his reduction in expenditure authority, the committee put out an interpretation document about a month after the change of control explaining that temporary changes were not material. And that's at page 463. And why did they do that? They did that because they anticipated that people would have questions about what a good reason event was because the provision was not clear. And the committee gave that interpretation under Section 9.3G. So the committee determined that because the change happened 8 months after the change of control because of COVID, and it was temporary for everyone, that it was not caused by the change of control and it was not material. So my friend on the other side talks about causation. We can look at both Section 2S and the plan as a whole to see that there is a causation requirement. 2S uses the language prior to the change of control. So even there, it's requiring the committee to measure in terms of the change of control. The preamble also says that the plan was enacted to ensure there was not a loss of employees after the change of control. It was not for any event that could occur. And finally, this court's case law says that administrators have a duty to gather a full and fair review, consider all of the facts, and that's exactly what the committee did in considering the cause of that.
I'm just wondering, Ms. Williams, has the committee approved any severance payments under these tests?
So it is not in the record, Your Honor, and as you know, you're bound to the administrative record, but my understanding is about 80% of the claims were approved, roughly 500 claimants. So this has certainly not resulted in litigation for the vast majority of those. So going next, Miller also complains that his relationships with trade organizations were diminished. And again, the committee considered all of the evidence. It met 6 total times. It interviewed 6 different people, both legacy Anadarko, both legacy Oxy, and it found that per Kershaw, the core of Miller's duties was regulatory oversight. It was not these trade alliances, and that's at page 825 of the record. My friend mentioned that 50% of Mr. Miller's job was advocacy, and I've not seen that number before. I'm not sure whether there is evidence in record of that. The committee also understood that Miller wasn't the sole decision maker before the change of control with respect to these trade organizations. He could not unilaterally find one, develop a relationship, spend the money, etc. It was subject to other approval. And finally, Miller fails to provide actual evidence to show that that factor was a material diminishment. He doesn't bring forth evidence before the committee or in his briefing to show what percentage of his time he spent on doing that, perhaps how it halted him from doing his job in other areas. So we simply can't tell from the record. And the substantial evidence before the committee was that that was not a material part of his job. Finally, to the extent that he complained of a loss of hiring and firing authority or reduction in reports to the committee, he doesn't pursue those in his appellant's brief to this court, so he's waived those. So when we step back and we look at, as a whole, Mr. Miller's job before and after the change of control, there was not a material and adverse diminishment, and he did not suffer a material reduction in his salary. And turning to my third point, even if the court applies de novo review, the committee's decision should be affirmed for all of the reasons that I've discussed. The committee's decision was the correct one, and Mr. Miller was not entitled to benefits. So the Anadarko appellees respectfully request that this court affirm the district court's judgment, and if there are no further questions, I'll rest on my briefing.
All right. Thank you. Mr. Lawson.
Thank you, Judge. I'm going to address a couple of points briefly. I direct the court to records 541 to 542, because that's the letter from Mr. Sanders, who was Mr. Miller's supervisor prior to the change of control event. And it's in that letter, I believe subparagraph D, where he outlines how important Mr. Miller's role was with the trade organizations. And when I argued that that was 50% of Miller's role, I wasn't referring to minute by minute throughout the day. What I was referring to, because we don't have that in the record, what minutes he spent on each thing. What I was referring to is the 2 pillars of his responsibilities, which are regulatory affairs and advocacy, and that was one of the 2. So I encourage the court to review that letter. Also, the Dalbertson case, which my friend brought up, I agree is a very important case. I disagree with how closely my friend says we apply to it. But we're very close. In fact, Mr. Miller experienced even more change than Dalbertson did. Miller not only lost 60% of his regulatory work to Ms. Halftop, but he lost all of his advocacy work. He lost 99% of his expense authority. And he was removed as a voting member of the management committee. Those, I would submit, are all very important responsibilities and duties that he enjoyed prior to COC. I also will address the argument about the temporary restrictions that is supported by the plan and causation is supported by the plan because it refers to time temporal before the plant COC versus after. I think the plan does give guidance, have a carve out to account for causation in its way, and that is the 1 year time limitation. Right? These employees are required to submit for COC within 1 year of the COC event. But that's it. It doesn't also say, and it has to be related to COC. It just has to be done within the year. And as I mentioned before, this is an important employment agreement negotiated by employees and their employer prior to the COC event. This is how both the employees and the employers navigate the change of control environment. You don't have to stick to the contract. And, Your Honor, if you don't have any other questions, I'll leave it at that.
Well, thank you very much.
Thank you.
Court will stand in recess until 9 o'clock tomorrow morning.